For years, police have used the smell of marijuana as probable cause to search someone's car during traffic stops. It was a tactic that has helped police find drugs and seize illegal guns, but it also led to some questionable searches. However, the Minnesota Supreme Court recently upended that entire practice after a ruling that the smell of weed is no longer enough. Fox 9 investigator Nathan O'Neill joins me now to explore these ripple effects. Nathan?
Yeah, Amy, well, the police training instructors, they say this new ruling is fundamentally changing the way police do their jobs. And we decided to really dig into the impact of this. We looked at police video, evidence files, and court records, which all show how police previously used the smell of marijuana to search someone's car. But that all changed after one search in Meeker County that made its way all the way to the Minnesota Supreme Court. Take a look.
How we doing today?
Doing good. Officer Ryan.
At the center of that landmark ruling is this never-before-seen video.
Partner said he told me he could smell weed, and I can smell weed. Okay, so I guess that's probable cause to search the vehicle.
This search in 2018 led to the discovery of a small amount of meth
And this.
and criminal charges.
You're under arrest.
But late last year, the Minnesota Supreme Court found that search unconstitutional.
The specific question is really whether the odor of marijuana alone is enough to expand the search to the vehicle.
The court ruled the odor of marijuana alone is simply not enough in Minnesota.
Okay, so Nathan, I think one of the first things people are going to think about is the fact that recreational marijuana became legal in 2023 in August. So does that make this a moot point?
Short answer, no. The justices, when they looked at this, they did not directly address the idea that Minnesota was headed toward legalization of recreational marijuana. They knew it was coming, but they did not directly address it. They kind of spoke to other states as examples that have gone through this process, made similar rulings, and then saw legalization take effect. And in those cases, those rules upheld. So we can effectively say that this is going to stick around.
Okay, and I think we should clarify too that while smoking recreational marijuana is legal in many locations and places in Minnesota, we need to clarify what that means as far as a vehicle goes, right?
Right. So even though you are legally allowed to possess it in up to certain amounts, you can smoke it, you can consume it, but state law does not allow you to do that inside your vehicle. So that is still a crime. As far as these searches go, the justices really kind of honed in on this idea of the smell. So regardless of the legality of everything around it, the decisions that were made as far as searching vehicles really comes down to the smell of marijuana and just that alone.
And that's not something you can really prove. It's not tangible, correct? Which makes it so tricky.
Right. There's nothing that you can collect as far as evidence other than the police officer's word, documentation. I mean, sometimes you can see that officers will use that and verbalize that in body-worn police camera footage. But as far as bringing proof that there was smell to a courtroom, you can't really do that.
All right. So as you were saying, this has upended, the Supreme Court decision now has upended a lot of existing cases, and you guys were able to profile a few, but walk us through one in Eden Prairie that you thought was particularly interesting.
Right. So obviously we looked at the Supreme Court case that made a big wave and big splash for that individual person, that stop, right? But it has far-reaching implications as far as all of the searches that are happening in Minnesota involving police and vehicles. So we started looking at, well, what's out there that is up for question. There are certain cases that were in the courts that really started taking another look at how those searches began and whether they were considered legal under this new understanding of the law. One specific case that we looked at was in Eden Prairie. A stop there. We have some video you can check out.
Okay.
On this late October night in 2021, Damian Marshall was pulled over by Eden Prairie police.
Where you coming from tonight? I was coming from the casino.
This video, obtained by the Fox 9 investigators, shows what started out as a traffic stop over dark-tinted windows. But what happened next would spark a 3-year ongoing legal battle.
No marijuana in the car today? No whatsoever. Okay.
Marshall was initially pulled out of his car because of an unrelated warrant. But that's not why the officer proceeded to search his car.
Until after we search it because of the odor of marijuana.
Oh, yes, sir.
He said the odor of marijuana, could you step outside the car?
In his police report, the officer also noted Marshall had constricted pupils, but he said he conducted the search due to the odor of marijuana.
Yeah, he's robo-tripping.
The officer found empty medicine bottles, marijuana debris, and a styrofoam cup filled with liquid, none of which were collected.
So I'm just gonna go ahead and dump this out because I'm not gonna try and collect it, but there's a mixture of pop. It's got a alcohol odor to it. I'm guessing it's the cough syrup.
Why did you have those containers?
Because those are the meds that my doctor prescribed for me to take.
The evidence found in the search ultimately helped convince a judge to order a blood draw. Traces of oxycodone and oxymorphone were found in Marshall's system. He was charged with a 4th-degree DWI.
He is not impaired, and he was using his prescription medications responsibly, which the blood results show that it was only a therapeutic level of what was in his system.
Did you feel like your rights were violated in that moment?
Yes.
Why?
The things that happened after the stop was against my Fourth Amendment rights.
That's the same argument Marshall's public defenders made in court, that the smell of marijuana alone was not enough to justify the search.
Any officer could say they smelt the odor of marijuana, and unfortunately, there's no way for us to know later on if that really was the case. We're not there. We're not present. We don't smell it ourselves.
Ultimately, a judge dismissed all charges against Marshall, citing a recent Supreme Court ruling that impacts traffic stops, police searches, and criminal investigations across Minnesota.
And we should note in that initial kind of interaction between the driver there and police, we mentioned in that segment that the individual had a warrant for him. But it's important to note that that warrant wasn't to search a vehicle. So even though an individual might have a warrant for their arrest, that doesn't necessarily give an officer the right to search a vehicle.
Interesting. Okay. In this particular case, there were some medications and some of those drugs that were found in his system that he says were prescribed by his doctor. In other cases, though, there may be, let's say, weapons, or maybe a felon in possession of weapons, or something deemed much more serious in those cases. So someone might say, well, isn't it worth it to make these stops if we end up sort of thwarting more serious crimes?
Well, I think you have to kind of look at it historically, right? We've seen police use this as a very easy foot in the door to get into a vehicle and search it. So yes, they have used that as a way to find illegal weapons, more serious drugs, find other crimes that might have been present inside that vehicle. And that's kind of what has historically been the practice. According to the Supreme Court, though, the fact that they opened the door through an illegal method, which was basing it on the odor of marijuana, anything that search uncovers is not admissible in court. So they call it, in the legal term, they call it fruit of the poisonous tree. So anything that you find after that point has to be thrown out. And that is at least the standing if you're going to adopt that defense in a case like this.
And on the flip side, cases for years that have not maybe made it as far, or someone didn't have the defense attorney they needed, people have served time and faced some serious consequences based on this type of a search that has now been deemed illegal. Is that right?
Presumably, yeah. I mean, if you look at, again, historically, some of the cases that have been fully adjudicated, people have been sentenced, they have served time, those cases have come and gone. But if they were to be tried today in today's court system and today's legal understanding, they might not hold up. But according to the Supreme Court, you really, in that ruling, it doesn't really apply retroactively. What we're seeing in our reporting and from our legal sources is that the cases that are kind of under consideration for getting a second look are those who haven't been fully adjudicated. They're still making their way through the court system. There's appeals. So there is a chance for people who are still up to make that argument. They still have that opportunity. But as far as people's cases who have been open and closed, that's in the past.
Okay. Is there some movement on an appeal on the Supreme Court ruling by any chance?
Not specifically on the ruling itself. However, you're going to see, and we're already seeing this through a lot of these cases, that there are prosecutors that are trying to find where that boundary line is. So there's going to be some testing of how far you can go on one side. The defense is going to push it in the opposite direction. So you will see the testing of the parameters in the legal system. And we've seen that with the case that we just highlighted in Eden Prairie. I just learned from the source there that that case is actually going to be appealed by the state. For the circumstances of his case, not necessarily the Supreme Court case itself, but for his individual case, and that's going to the appeals court in June.
Okay. I imagine this is going to be a really tricky, it's going to be tricky for law enforcement to figure out how to move forward through this and keep these searches legal, right?
Yeah, and we're reporting that's a big question that we wanted to explore, which is how do you adapt to that changing landscape? And this is a piece of the report that we have, so you can take a look at.
Okay.
Now, some cases like this one out of Savage
I smell marijuana coming out of your vehicle.
are under growing scrutiny.
I'm going to search the vehicle.
Are you serious, ma'am? Really?
Yes.
Why? Why?
Because your vehicle smells like marijuana.
Are you serious?
Yes.
This driver was pulled over for speeding, but everything escalated when he told officers he had a gun in the car.
Do not reach for anything. Get the out of the car and do it now. Get down on the ground. Don't you ever reach like that when you're dealing with me. You understand?
The driver was convicted of having a firearm without a permit and obstruction, but this case is now being reviewed again because of the Supreme Court ruling. That ruling is also leading to a shift in policing tactics. The Fox 9 investigators identified at least 3 police training programs in Minnesota that are adapting their curriculum to the new legal landscape. One instructor predicted that because searches based on odor made it, quote, easier for police, the ruling will reduce the amount of vehicle searches overall.
Either the police will adapt and that will be that, or they don't and we continue to get dismissals.
Interesting.
Yeah, so I mean, that is one of the big questions that we set out to find out, which is how are these policing programs, training programs adapting to this legal landscape? And what we're finding is that, at least from our survey, which we conducted of these programs across the state, is that they're going to have to retrain or they're going to have to reform their approach on how they train officers. For years, there have been instances where training programs would bring in burnt marijuana for officers to actually smell so they could get familiar with it and use that as a basis for building that probable cause to gain access into the car. That doesn't really happen anymore. But we do know, as far as the training programs themselves, they are adjusting their curriculum accordingly.
Okay. These officers, anybody I think could agree that when they enter these situations and they're pulling someone over, it is potentially a deadly situation. It can be a dangerous situation. They have a job to do here. And so they've been trained in a certain way. Can we break down sort of the rights of the person in the vehicle, right? Do they have a right to deny searches, that kind of thing? And also the motivations of these officers as to what they're looking for.
Sure. I think the motivation comes down to a couple different things. So if we're looking at the cases that we have explored so far, all of the judges in those cases laid out that there was no wrongdoing on the part of the officer because they were following the law as it stood in that time frame. Obviously, things change, and now there's going to be an expectation that when an officer wants to search a vehicle and they're leaning on an odor of marijuana to do so, there has to be something else. So it has to be an odor of marijuana, and maybe they saw an individual driving erratically and they believe that they're under the influence. That could be a potential reason. Maybe they see them smoking and that's a visible cue. That's something plus odor. So it can't just be odor alone. It has to be some other observation or evidence that is procured by one of the officers.
And it's important for people who may be in their vehicle smoking marijuana visibly to understand once they do that, they've broken the law, and you refer to it in your piece as sort of that opens the door, right? So do you want to explain what that opens the door to?
Sure. Well, I think that is kind of an open question on whether an officer will use that as an avenue to conduct a search. Like you mentioned, it's illegal to consume in your car. It's also illegal to have cannabis, marijuana in the front seat. You have to treat it almost kind of as an open container law. So that is also against the law. How that will particularly be enforced and how harshly, it's yet to be seen. But I think it does raise the question on exactly how these officers are going to really kind of try to adapt and still do their jobs.
Right. There's so much that remains to be seen here, right? My goodness. Well, if you want to watch Nathan's full story, it's a fascinating piece. It's on fox9.com. For those of you who are watching on Fox Local, we'll send you back to All Day.